Arkansas court sees through USAable's life's ploy of considering just the physical, material, and substantial duties of the policyholder's occupation. Carriers play many denial games. One of the worst games is to consider just the physical requirements of the policyholder's occupation and ignore the cognitive requirements and the social or psychological duties of an occupation. That isn't right. In the case of Rays versus USAable Life, the Arkansas court, using what's called a de novo standard of review, called them on their denial. Now, a de novo standard of review is where the judge gets to substitute their own judgment for that of the carrier. Rays was a mental health professional at Western Arkansas Counseling and Guidance Center. He became disabled as a result of severe neck pain, joint pain, headaches, and fatigue. Now, what the disability carrier did was to have their vocational evaluator determine that his job was sedentary, and then they used their peer-reviewed doctors to reject Ray's treating physician's opinion that there was no impairment of function. So they denied the claim based on the strength of their own peer-reviewed doctor and a vocational counselor. And on appeal, the denial was upheld because they said that Rays could do sedentary work, and they even rejected the Social Security Administration's award of disability benefits. Now, fortunately for Rays, the Arkansas law doesn't permit discretionary clauses in disability policies issued in the state of Arkansas. So, as I said, the federal judge could review the case under the de novo standard of review, which means the judge gets to substitute their own judgment for that of the carrier. Now, this policy provided that to be disabled, the policyholder had to have an injury or sickness that prevented them from performing at least one material duty of their occupation. The policy defined material duty as the set of tasks or skills required generally by employers from those engaged in the occupation. Now, the disability carrier considered only the physical requirements of the occupation. They ignored the material duties outlined in the Dictionary of Occupational Titles definition of this position and the tasks and skills that were required by the employer. The federal court found that she had been deprived of a full and fair review of the claim and remanded the case back to the carrier to reopen the record and gather the necessary information about the material duties, tasks, and skills required of the occupation. The lesson learned here is to challenge any misclassification of a policyholder's occupation or a failure to consider all of the occupational duties, be they physical, cognitive, psychological. I think you need the help of a nationwide ERISA disability attorney such as myself who knows every step to overcome a wrongful misclassification or the carrier's failure to consider all of the occupational duties, be they physical, psychological, social. They need to be considered individually and in total. If your claim has been delayed or denied, call me today for a free complimentary consultation, 727-894-3188. I look forward to helping you get the disability benefits you deserve, regardless of where you live in the United States.